Good morning. Thank you for joining me this morning. I'm going to be talking about implied representations and representations by conduct. And I'm going to be talking about some recent cases and also the principles behind those decisions. But before I do that, I thought it would be worth just summarising what's required in general terms to establish claims in deceit and misrepresentation. The basic elements are set out on the PowerPoint slide, which I hope you can all see. For a claim in deceit, essentially, there are 5 requirements. And then when it comes to contractual misrepresentation, to avoid a contract, there must be a false statement as fact or law that's intended to be relied upon, although a claimant can also take advantage of Section 2 of the Misrepresentation Act 1967 to effectively reverse burden of proof, so that the person who made the statement is liable as if it had been made fraudulently, unless he proves he had reasonable grounds to believe it, and did believe it up to the time the contract was made. So really, when we're talking about fraud in this seminar, we're talking about claims in the tort of deceit, which is a claim, common law tort claim for damages, and misrepresentation claims part of the law of contract. And as I say, I put up a reference there to a case from Mr. Justice Jacobs about Nielsen Holding, which summarises the principles, although other summaries are available. And in this talk, I'm actually going to be talking about the first requirement almost exclusively, and only part of that, and that is whether or not there is a representation at all that can be implied from conduct. But implied representations are a bit broader than that, so I'll just give a bit more background to the talk. In what circumstances do they arise? Of course, in general terms, no representation is made, fraudulently or otherwise, by silence, and the general rule still holds that mere non-disclosure does not constitute a misrepresentation. But there are well-recognised exceptions to that principle. I put some of them up on the slide. One may be if there is a duty of disclosure, which can arise in certain insurance contracts, often if there's a fiduciary relationship, perhaps. An interesting recent case involving that is in respect of defects in title in property transactions. That's the case of SPS Groundworks and Mayhill. But secondly, there may be cases where there's a failure to disclose something that distorts a positive representation that has been made. There are 2 particular cases of that. One is when there's partial non-disclosure, and perhaps one of the cases you may have come across in this area is Curtis and Chemical Cleaning and Dyeing Company Limited. That's the case where the effect of a dry cleaning receipt was said to be to exclude liability for damage to beads and sequins, when in fact it excluded all liability. So you can see that might be viewed as a half-truth. And the second type of case that falls within this heading is where a representation's made, but it carries with it an implied obligation to correct it if it turns out or it's discovered that it's not true later on. The third type of case are cases where a statement of opinion has been made, and that can often carry with it an implied representation that the person making the statement has reasonable grounds for the opinion. Not always, but an example of a case where that implied representation was also found is Brown and Raphael, 1958 case. That concerned an honest statement made by a solicitor who did not have grounds for making the statement. And the solicitor was held to have made an implied representation that there were grounds to do so. And it was that representation that was false. So those are all pretty well recognised cases of exceptions to what might be said to be exceptions to the general rule that there's no misrepresentation by mere non-disclosure. And then there's this fourth category, representations that also arise by conduct, that I'm going to concentrate on in this talk. And before looking in more general terms at that category, it's also worth, I think, looking at a particular case of concealment by conduct, which again, I think is fairly well recognised now. And this crops up in transactions where there's a property transaction or a transaction involving goods where a seller takes some active step to conceal a defect that would otherwise be apparent. I've taken these three examples from Titian contracts, so some of them are quite old. One is nailing down planks and closing the seams with rotten ship. The second, plugging a hole in a gun with soft metal. It's a bit extreme. And thirdly, more recently, deliberately covering up dry rot in a building that you're going to that someone was going to sell. That's a case called Gordon and Sellico. But again, the principle that you can have representations by conduct is wider than this category too. And perhaps, so one of the most well-known cases that illustrates the point from some years ago now, in 2002, is the Spice Skills Limited and Aprilia case, in which the Court of Appeal found that conduct by the Spice Girls, together with related documentation, amounted to a series of continuing misrepresentations that the group was unaware that any member had declared an intention to leave before the minimum term of sponsorship agreement expired. Now, sadly, as I'm sure many of you will remember, in March 1998, one of the members of the Spice Girls told the other members she did intend to leave and subsequently left after the group and that claim succeeded. But the facts of these cases are all quite specific. But the principle, I think, that comes out of it is more interesting and more important. And what the Court of Appeal said that was that whether any, and if so what, representation is to be implied is to be determined objectively in light of what was said and done. In any event, music and the law have moved on since 2002. And I'm going to pick up now, I think, a series of cases from 2018 and 2019 that relate to the LIBOR and Euribor scandals, because this is another area where there have been quite a lot of decisions on implied representations. The first case, one from 2018, considered implied representations. What I'm going to talk about is a case that went to the Court of Appeal. It was called Property Alliance Group Limited and Royal Bank of Scotland PLC. And it was a claim for losses incurred by bank customers as a result of interest rate swap agreements. And one of the issues the court had to consider was whether there was an implied representation made by the bank that it was not seeking to manipulate the LIBOR rate. Now, in a lengthy judgment, the Court of Appeal held, I think this is at paragraph 132, that it was a helpful test in relation to the existence of an implied representation to consider whether a reasonable representee would naturally assume that a true state of fact did not exist, and that if it did, he would necessarily have been informed of it. But that is not to water down the requirement that there must be clear words or clear conduct of the representor on which the relevant representation can be implied. Now, in the PAG case, the Court of Appeal was satisfied that there were lengthy discussions before the swaps were concluded, in the context of which RBS did make some representation to the effect that it was not itself manipulating or intending to manipulate LIBOR. On that basis, I think the Court of Appeal disagreed with the trial judge, although the claim failed as neither the trial judge nor the Court of Appeal was satisfied the manipulation by RBS had been established. Moving forward a year, in 2019, the case of Marm, Inversiones, 2007, and NatWest Markets PLC was also heard. Now, in this case, the claimant company sought damages against some banks for, again, for alleged implied misrepresentations and the rescission of interest rate swaps, which it had entered into on the basis of those representations, and which concerned the Euribor benchmark. Now, the alleged representations were broadly to the effect that the first defendant had not sought to manipulate Euribor, no reason to believe that other banks were seeking to do so, and had not conducted itself in such ways to undermine the integrity of Euribor. And the claimant in this case relied upon the behaviour of an employee who'd been convicted of conspiracy to defraud in respect of attempts to manipulate Euribor. But the claim again failed. Now, I think it was Mr. Justice Pickin and Howard at the case, and this is often a case that you see referred to in judgments concerning implied representations, because the judge distilled a number of principles, 4 in total, from those authorities apply to the case of implied representations. Although, of course, these are cases that are quite fact-specific, I'll just mention what those 4 principles are, because they'll come up again in other cases that we talk about. So first, it is possible, I think it's well known, for representation to be expressly or implied, or to be made expressly or impliedly through words or conduct. For a representation to implied silence or mere assumption is not usually enough, as there's no general duty of disclosure. It's necessary to view the words or conduct objectively to determine whether an implied representation has been made, although the natural assumptions of the reasonable representee will be helpful. Secondly, whether or not a representation is implied is ultimately a question of fact, to be determined in the circumstances of the particular case. And thirdly, more may be required in terms of words or conduct for a representation which is wide in meaning or complex to be implied. And fourthly, related to that, it's less likely that a representation that is vague, uncertain, or ambiguous would be objectively understood to have been made from words or conduct. Now, in the Marm case, as recorded by the judge, paragraph 125, there are a number of difficulties with the case on implied representations. One of which was that Marm had changed its case on which implied representations had alleged on 3 occasions without changing the conduct on which it relied for the implication of those representations. And as the judge said, there was a strong suspicion that the representations were the result of reverse engineering inspired by the Court of Appeal decision in PAG. Albeit, the judge also accepted that by their very nature, implied representations are not expressed in words, so that it will almost always, for practical purposes, be the lawyer's task to put the conduct relied upon into words. So, if you're looking to bring a claim on implied representations, they do need to be clear and unambiguous and based on an objective understanding of the conduct of the representor, rather than assumptions on the part of the representee. And there's another useful summary which I've just flagged up on the slide. That's on the Pisanti and Logothetis case. I haven't put the name up, but the reference is there. It's 2022 EW8C 161, paragraph 6. And I think it's Mr. Justice Andrew Baker that develops these concepts and makes the point again that it's clear words and conduct that are needed. Representations won't be implied from conduct that is vague, uncertain, imprecise, or elastic. And another point, which I'll touch on briefly, is that for a claimant to establish reliance, he also has to show that he understood the representation in the sense alleged. And that's a point to be careful about, especially if the conduct's being looked up after the fact to see what it may have implied. So, moving forward again then, further claims from 2023. Well, the problem with implied representations was highlighted again in a recent case. This is the Manish, Goyal and BGF Investments Management Limited. I think it says BFG on the slide. Anyway, it was a decision handed down by Mr. Justice Butcher on 26th of May. And in this case, the claimant claimed damages for deceit and unlawful means conspiracy against the defendants in relation to a share divestment transaction. The claimants were shareholders in a company which ran an IT consultancy business. The first claimant had been the chief finance officer. The second claimant was his wife. And the defendants were the former chief operating officer and investors who had taken up the opportunity to purchase a minority investment in the group. Now, following the completion of the transaction, the first claimant, the chief finance officer, was dismissed. And the claimants began proceedings alleging that during the negotiations for the divestment, for the share sale, a number of false representations had been made by the defendants that he would remain as chief finance officer, and that there was no intention to remove him, which had induced him, and by extension his wife, to enter into the transaction. Now, I think it was Mr. Butcher J that heard this case. He adopted the general test for implication from Marm and NatWest Markets. And he also highlighted paragraph 157 of that judgment, which it was said that although passive conduct may sometimes be sufficient for the implication of representation, the broader and more complex the alleged representations, more active and specific the conduct must be to give rise to it. But differently, whilst it may be that some representations are legitimately to be implied, it is less obvious that intricate and broad representations should be implied from passive and necessarily somewhat limited conduct. Now, again, in this case, the judge wasn't satisfied that the implied representations had been made and generally didn't find the first claimant's evidence reliable. But it's worth noting that when looking at what was said in some meetings, the judge held that whatever account of that meeting was right. And he was of the clear view that one person saying to another, "That sounds good," or something like it, was not intended by him, would not reasonably be understood by the other person as more than an acknowledgement of what had been said, and in effect an invitation to move the conversation on. So again, it highlights the fact that if you're looking to imply representations, relying on words like that at the end of sentences probably isn't a good place to be. As I said, it reinforces the point that misrepresentations should not be too easily found. This is the general approach that's taken, at least for there to be implied from conduct. The second case I thought I should mention is the Laura Lee Fine Outsourcing Jersey case. Now, this is a case where the claimant sought damages from the bank for fraudulent and negligent misrepresentation. And in 2007, the claimant bought some AAA rated notes from the bank, the purchase of which formed the basis of a synthetic collateralized debt obligation, which was secured against a portfolio of some residential mortgage-backed securities. So a lot of acronyms involved in the transaction. But in any event, the claimant lost money on it, and in 2018 it brought proceedings asserting that it had been induced to enter into it by false representations. Now, this was another case where the representations that were alleged were quite complicated. In fact, they were so complicated, the judge had to break them down into groups. His judgment, group one, he called the honesty representations. Group two, actually I say he, I think it was Mrs. Justice Cockerell in fact in this case, but group two, representations relating to credit rating. Group three, ability to make an informed determination of credit quality, and group four related to a draft memorandum and obligation of good faith. So again, this case contains, I think it contains a useful summary of a law, including a court should be cautious, so that implied representations are too easily found, and the more complicated the representation is, the more difficult it might be to imply. As it happened, the judge held that representations were not made out, and the claim was dismissed. And to that extent, I think it was consistent with the principle we've already been discussing. But it's a useful judgment because it also contains some guidance on some other points that often rise in these cases. And just to, well, I should also point out, so it also contains a list of, I think, 9 cases where implied representations relating to honesty have been said to be found too, starting with the Gordon and Selico dry rock case that I mentioned at the start of the talk. As I said, the decision also includes a discussion of the extent to which a representee has to have an awareness or understanding of implied representations. That's, I think, from paragraph 384 onwards. And to some extent, it's easy to see how that issue often rises in these types of cases, because if a representation has to be constructed or is constructed from conduct after the event, how can it be said to be an inducement, at least unless it is somehow in the mind of the person to whom the representation is made in advance of the contract? And there is, or there has been, a series of authorities addressing this point. I think the discussion arose primarily from arguably the different approaches taken by Mr. Justice Waxman in Crossley and Volkswagen, the 2021 case that was part of the diesel emissions scandal litigation, and an earlier decision of Cockerill J in Leeds City Council and Barclays Bank in 2021. In essence, in the Leeds case, the judge struck out the claim because the representees could not show that they were aware of the implied representations when they were made. In Volkswagen, Mr. Justice Waxman refused to strike out a claim based on a similar sort of argument, although that's, I think, to oversimplify the points considerably. But at least in this case, the already financing, the judge, Cockerill J, held, I think this is paragraph 421, that the law does require that a representation, however made, is received by the representee, and that to satisfy the requirements of reliance, the representee must be aware of it, have it actively present in their mind when they act upon it. Although it's worth bearing in mind that there may still be cases where the representation is so obvious that not much, if any, thought needs to be directed towards it. A classic example of that, except in later cases, and indeed in this one, is the judgment in the case of DPP and Ray, where there was an implied representation to a waiter that customers intended to pay for their bills, and it was effectively so obvious that the waiter couldn't be expected to have that actively in their mind. Or if they did, it would be so obvious it went without saying. Those are some important cases, I think, from 2023. And what about from 2024? Well, there have been some cases this year too on implied representations on this conduct in this context. Tactus Holdings was a case involving a company acquisition that was handed down in March of this year, a decision of Simon Colton KC, and it was an application for reverse summary judgment on claims, some of which were based in deceit. Now, this claim arose out of the purchase of an online technology retailer, and the part of the claim concerning deceit and misrepresentations related to representations said to be made concerning stock provision, that's to say, downward adjustments to the value of stock held by the company as shown in its accounts. Now, in considering this application, the judge drew on the summary of the law from Laurel. It was primarily a case concerned with express representations, but it was also alleged that there was an implied representation associated with one of the express representations, namely that there was a reasonable basis for making it, as opposed to the sellers merely having an honest belief in the representation. And the judge found that wasn't made out on the facts there. The second case I mentioned is the Fowler Holdings case against Clydesdale. It's a decision of Mr. Justice Zaccaroli, handed down in March 2024. This was a case that concerned claims made by 4 businesses in relation to fixed rate loans provided by a lender. And as part of the claim, the claimant businesses claimed that the defendant banks had made fraudulent or negligent misrepresentations and misstatements when entering into the loans with them. Those representations were broken down into so-called rate cost representations and also fixed rate representations. Now, the claim didn't succeed, but the judgment, again, contains some useful guidance, I think, on pleading implied representations and also on how to aggregate conduct in respect of them. So I'm just going to pick up on those 2 points. Pleading, this goes back to a point I mentioned earlier, in fact, about the level of awareness and what has to be understood by the representee, which is something to bear in mind, I think, in particular if you're looking at the conduct afterwards, or a lawyer's looking at it and trying to see what could have been implied. And at paragraph 409 of his judgment, the judge held that although chronologically the pleading comes before witness statements, it's the central prerequisite for claiming implied representation, that it's based on the evidence of the relevant representees as they understood the implied representations to have been made to them. It's accordingly necessary for the representee to be able to give evidence that, on the basis of what was expressly said to them, they understood something else to have been implied, and what they understood to be implied was, substance at least, the same as the pleaded representation. So when pleading or advancing a case based on an implied representation, it's important not to plead a case that's inconsistent with the witness's understanding of what actually happened. And then at paragraphs 414 and 415, there's some useful guidance again on how to aggregate statements and what's permissible and what isn't. So when looking at the whole course of conduct, it is of course permissible to view statements made to a representee on different occasions as a whole, that's to say, to look at the combined effect of what's been said at a time. But it's important to take care not to conflate statements made to different persons, for example, different employees of the same claimant, unless there is evidence that decision makers of the claimant were aware of those statements. So some good points, I think, to take from that decision. Moving on, Hamoudi and Lombard. This is a decision of Judge Pierce, sitting as a High Court judge, handed down in June of this year. Now, in Hamoudi, the court refused to strike out a claim that the defendant, when selling shares in a third party to the claimant, had impliedly represented that it had no material non-public information about the third party, albeit other aspects of the claim were struck out. Again, the judge went back and applied the test from the Marm 2007 case. He declined to strike out this part of the claim, that's on implied representation, on the basis that it was a question of fact, not law, and it's therefore a matter which the court should be cautious about determining on a strikeout or summary judgment application, as it may be that careful analysis of the discussions involving the claimant and the representatives of the defendant would lead to the conclusion that the representation was impliedly made. For that reason, notwithstanding his doubts about the strength of the argument, the judge declined to strike out the claim. So I think that's a useful case to have in mind if you are considering or applied strikeout, or indeed defending a strikeout application that involves an implied representation. Though it's equally worth bearing in mind that other judges have struck out these claims on different facts. And then the final case I mentioned is one from July of this year, and it was a case Nord Partners where the court was in fact satisfied that there was an implied representation. And in this case, the providers of a revolving loan facility succeeded on their claims in deceit and unlawful means conspiracy against the borrowers. Part of the claim related to a statement of net worth that had been provided to the lenders that subsequently transpired to be an overstatement. And the implied representation in this case related to the statement of net worth, because the judge was satisfied that it either expressly or impliedly represented that, firstly, the borrower personally owned each of the assets listed, and secondly, he honestly believed each of those was worth the net value ascribed to it in a table. Now, what you'd probably take from that is that that's quite an obvious representation. It's quite short, and it's quite easy to explain what it is and why it comes about. And those are the sorts of features, I think, that you should be looking for. And I've almost been going for 30 minutes. I'm not going to go for much longer. I just thought I'd mention a few useful general points in dealing with these types of claims. Three of them in particular. The first is just that, of course, it's worth always bearing in mind that the Avon Insurance PLC case, because to defeat a misrepresentation claim, it's not necessarily true, not sometimes necessary to show the representation is entirely correct. Establishing that it's substantially correct can be sufficient, may be sufficient. Secondly, directors and their liability. Where a director has made a fraudulent representation, intending another person to rely on it, and the other person does so, the director, of course, is usually personally liable. And that's not because it's not because that person is a director, but because that is the person that's effectively committed the fraud. And employees can also, of course, be liable vicariously in the tools of deceit in certain circumstances. And also bear in mind, of course, Section 6 of the Statute of Frauds Amendments Act 1828, which places a limit on liability and deceit for a representation made relating to the character, conduct, credit of people, persons, where the intent or purpose of that representation is that the third person obtain money or goods on credit. One of the limits of that section now set out in the Court of Appeal decision of Rhoda UK Limited. So, in conclusion, I think it's fairly clear that representations will not be easily implied by conduct. And if you are pleading them, I think it's worth keeping it simple and looking for obvious ones, and indeed checking that representee at the time the representation is made has the same understanding as is set out in the pleaded case. That's all I wanted to say. Thank you for joining me this morning. I don't have any questions in the chat, but if you do have any questions, hopefully I'll see you around in different events, and you can ask me about them then. So thank you for joining me anyway, and good morning.